Martin v. State is a case that helps us clarify the boundaries of the legal requirement of actus reus, or guilty act. Here's the legal question before the court. Did our defendant Martin violate statute prohibiting drunk people from appearing in public places? The court ultimately decides the answer is no, and let's take a look at the facts first, and then we'll take a look at the legal analysis. Here's our defendant Martin. He's at home. It looks like he's drinking too much, and he's probably being too loud because the neighbors call the cops on him, and the cops show up, they arrest him, and they go for a ride downtown. And somewhere along their way to the station, the cop decides to pull over on the side of a highway and drag Martin out of the car. I don't know if Martin's actually barfing. I made that up. But anyway, Martin certainly is swearing and cursing. And this is the thing that, on the face of it, that gets him into trouble. So that's it for the facts. Let's take a look at the legal analysis. Here's the relevant portion of our statute that the judge cites. So it says any person who, while intoxicated or drunk, so yes, Martin's a person, intoxicated or drunk, appears as our first element in any public place where one or more persons are present. So here I think, with a highway, certainly it's a public place. At least a cop was there, the police officers there. Presumably there were other cars and people driving, so this is fine. And manifest is the second element, a drunken condition by boisterous or indecent conduct or loud and profane discourse. So I think this part of the disjunctive is certainly met, loud and profane discourse, so this whole thing is fine. So our judge really doesn't focus on manifest. We focus instead on appears, and it's through the legal analysis on what it means here that we get a better sense of where the boundaries for actus reus lie. And the key to the analysis of this element appearance, our judge says, is that we have to understand appearance to mean voluntary appearance. Right? Even though the statute itself does not specify whether appearance means voluntary, our judge says just on the face of it, just on a plain reading of the text, we have to presume that's what the statute meant, is voluntary appearance. And we'll recall from the facts that while Martin certainly appeared in a public place on the highway, it wasn't voluntary. He was dragged there by the cops. So because of that, our judge says this element is not met. And that's it for this case. But how's this case relevant to your understanding of crim law? Well, you know that actus reus is a very important element in crim law. So the next time you encounter a fact pattern where the guilty act here was appearance, but it could be anything, where the guilty act potentially could be argued to be not voluntary, you have to remember this case, because this case demarcates a boundary for actus reus. It says that actus reus is not met when other people physically force you to commit the act. Now, of course, on an issue spotter, I doubt you'll get exactly the same elements. For example, other people, I doubt you'll get cops again, right? Or instead of a highway, it's a park this time. That's too easy. Those aren't like really relevant distinctions. Here's a relevant distinction. What if it were strangers instead? Right? Certainly the cop's a stranger. It's a cop. They have authority. Here's just a random stranger. Okay, what if they were your best friends instead that dragged you to a public highway to commit some boisterous, drunken behavior? How does that change the analysis? Right? What if the act wasn't something as innocuous, as benign as cursing? What if it was something a little more egregious? How does that change analysis? Right? So those are the things you should expect to get. I mean, what they're really doing is they're forcing you now to demarcate even finer the boundaries of actus reus.